If he does not have funds to pay off the judgment, then we will seek, judgment enforcement mechanisms in court, and we will ask the judge to seize his assets.
That was New York Attorney General Letitia James vowing tonight to make Trump pay the $355 million plus interest penalty from his civil fraud trial, even if it means taking buildings owned by the former president. But Trump appears to be resorting to alternative means to pay his legal debts. Over the weekend, the Donald launched his Never Surrender gold high-top sneakers. They retail online for the low price of just $399. The former president would need to sell over 1 million pairs of sneakers to pay the penalty from his New York fraud trial, which could take, I would argue, some time. Meanwhile, Trump is waiting on 2 Supreme Court decisions that could come down at any moment. One of the issues of immunity, which will determine whether Trump's federal decision interference case or federal election interference case can resume and proceed to trial, and another deciding whether or not to uphold a Colorado decision to remove Trump from the ballot. Melissa Murray joins me now to discuss this and more. She's a professor at NYU Law and co-host of the Strict Scrutiny podcast. It's great to see you, Melissa. Thanks for coming on the program. So Letitia James tonight saying that she is prepared to seize Trump's buildings if he cannot pay his civil fraud fine. How do you see this judgment playing out financially and politically for Trump? How much will it hurt his bottom line?
Well, I mean, it's obviously a massive judgment, not just the almost $400 million in the actual penalty, but also $100 million in pre-trial interest that's already accrued and continues to accrue. So this is a sizable judgment, the kind of judgment that could easily be satisfied with the seizure of a massive asset like a building. Letitia James has mentioned the Trump 40 Wall Street building a number of times at this point. But yes, this is a sort of standard way. Other assets could be used to satisfy that judgment. And this is pretty much standard operating procedure. There are other judgments that are also in the offing. There's also the E. Jean Carroll defamation verdict. That judgment was about $88 million. So this isn't the only financial problem he has on the horizon.
So let's turn to Trump's criminal exposure and the issue of immunity currently before the Supreme Court. Trump has already lost on this question of immunity twice. Tanya Chutkan ruled against him, and then the D.C. Circuit upheld Chutkan's decision. What are Trump's chances of getting the Supreme Court to grant this temporary stay?
I think it's very unlikely that the court is going to grant the temporary stay. I think it's also very highly likely that the court may just allow the D.C. Circuit's decision to stand. But I want to make clear here, it's not a question of what the court does. It's really a question of when the court will do it, because the longer the court spends deliberating on this question of whether or not to grant certiorari or whether or not to stay the ruling below, means that Donald Trump has won. We've already blown past that March 4th deadline to begin the trial in D.C. And the further out we get from an actual trial date, the more likely it is that Donald Trump will not go on trial at all. So the Supreme Court really has a role to play here, and its role is in making a decision and doing so with some measure of expedition.
If Trump is granted this temporary stay by the Supreme Court, when should we expect to see this trial getting underway?
Well, if the stay is granted, then I think all bets are off. But again, we also have the disqualification hearing that was last week or a couple of weeks ago that the Supreme Court also has to issue a decision on. And I think, again, sort of thinking about the optics here, it seemed very likely from the oral argument in the disqualification hearing that it was unlikely for the court to side with Colorado. So that's a win for Donald Trump to stay on the ballot in Colorado. And I think just making sure that the court sort of remains above the fray as this political cycle gets underway, it's very likely that the court is going to be looking for a way to deliver kind of loss to Donald Trump so it can appear even-handed. But again, a loss that comes with a big expanse of time is not really a loss at all. In fact, it's a win for Donald Trump.
Let me ask you about that Colorado decision and whether or not you think it'll come down to whether the Supreme Court believes that the states have the right to basically determine if this candidate or this person who's seeking office was involved in an insurrection, because they wouldn't be saying this if it came down to an age limitation or an age qualification. They know the states have that right. But would it come down to the interpretation of it, or why do you think the Supreme Court would not side with Colorado?
So there were a number of different theories floated at that oral argument. One is this idea that in order for Section 3 of the 14th Amendment to be operative, Congress has to first pass a statute. It can't just happen at the state level. Congress has to first authorize it. That seems to be where they were going with regard to this at oral argument, although many different theories were floated. All I will say about the idea that Congress has to first act is that there are a number of different provisions within the 14th Amendment, including Section 5 of the 14th Amendment, which authorizes Congress to act and legislate in furtherance of the aims of the 14th Amendment, which secures civil rights, equal rights, and due process rights to all Americans. This court has taken a very narrow view of Congress's enforcement power under Section 5 of the 14th Amendment. So it would be highly ironic and even a little inconsistent if it determined here that Congress had to first act before prohibiting the states from doing something when they've been very willing to let states move forward without having congressional approval in advance.
Yeah, I was going to say, I would not be surprised if this court is, in fact, inconsistent with many of its decisions, especially this one. But let me ask you finally, and it's kind of switching gears a little bit, still on the Supreme Court, but I do have to bring this up. This headline today: Justice Alito renews criticism of landmark ruling on same-sex marriage. Just your response to that.
Well, it's not the first time we've heard this from Justice Alito. He was a dissenter in 2015's Obergefell versus Hodges, which legalized same-sex marriage across the nation. In 2020, he and Justice Thomas also issued a separate opinion in a denial of cert that raised questions about Obergefell. So this is something that we've heard from him before. It's not surprising. I think, though, in the wake of Dobbs and the overruling of Roe versus Wade, it raises real questions about whether this court has an appetite for staying the course with established precedents, or whether they will seek the opportunities to revisit cases that have been settled.
All right. Troubling headline there from Justice Alito, but again, not surprising. Melissa Murray, always a pleasure. Thank you so much for joining us.